The First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
All right, please be seated. Welcome to the First District Court of Appeal. We have two cases on the docket this morning. And the first one is Leonardo Lynch versus Florida Department of Law Enforcement. Mr. Friday, are you ready to go?
Yes, Your Honor.
Okay, you may proceed.
Thank you, Your Honor. Eric Friday, on behalf of Leonardo Lynch, I'd ask to reserve 3 minutes for rebuttal.
Okay. You may go.
Your Honors, FDLE is engaged in a denial of the Second Amendment right of Leonardo Lynch. The questions presented by this case are, can a Florida agency deny a fundamental enumerated right without opportunity for hearing and without admissible record evidence? And can they avoid judicial review by refusing to render a final decision? FDLE's actions in this case violate Lynch's right to substantive due process in the exercise of his constitutional rights, and they violate the laudable statutory scheme created by Congress and the Florida legislature to both keep firearms out of the hands of the mentally ill without denying the rights of others. And
Mr. Friday, they argue that that there's a procedure that's set out by their rules that provides that your client has to go to New York and get whatever available record it is and then submit to them, and they can check to see, there's an appeals process where they check to see if the person that they think is your client is your client, that he's truly a prohibited person.
Your Honor, there are two problems with that process and procedure, two main problems. The first is that they don't have the authority to make such rules. 790.33, the preemption statute, prohibits them from making any rules they're not specifically granted authority to make. While the legislature did give them authority to create rules for the review of criminal records, the Florida legislature did not give them any authority to create rules for the review of mental health records. Those are two very distinct terms in Florida statutes, and we have numerous opinions and decisions of various courts that processes of mental health are do not implicate criminal law.
Okay.
Second problem.
Here's a related question I have to that. And I understand what you're trying to say, and I'm not trying to cut you off, but we have limited time for argument, and I have a lot of questions because I'm trying to understand this. How much of this is mandated by federal law? Because they're federally, there are prohibited persons and they have procedures that they have to follow. How much of FDLE's procedure is kind of imposed on them by the feds?
Your Honor, I'd say none of it. And the reason is both federal law and Florida law are fairly consistent with each other. And the consistency is that there is processes, but the federal government in the Brady Act did not mandate any of these remedies. They are available remedies. They do not preclude any other remedies under state law, would be the first issue. The second issue with what they're arguing is that they have to have some evidence, even under their rules, if applicable. And I'll go back to your last question briefly. They have to produce something to Mr. Lynch so he knows exactly what it is he supposedly is accused of. Just as an example here, they say, well, it was either a mental health commitment or a substance abuse commitment. We're not quite sure which one. You go to New York and figure it out, Mr. Lynch.
They're saying that they can't get the record from New York because it's a confidential record. And Mr. Lynch apparently can waive confidentiality and get the record. Is that incorrect? Or?
Your Honor, I honestly don't know. I mean, presumably he could waive confidentiality. But again, we come back to the question of the state wants Mr. Lynch to go and obtain evidence for them in regards to their denial of his fundamental rights. And that's not a process we would allow anywhere else, and we shouldn't allow it just because of we're dealing with a firearms issue. The right
Mr. Friday.
Yes, Your Honor.
So why then why not bring a rule challenge to challenge this rule on the grounds that you've already articulated?
A rule challenge in, for example, the trial court, Your Honor?
Or at DOA?
Well, a few reasons. Number one, the process that the procedural posture this case came to me in was that Mr. Lynch had been denied a right. There's a related case to this one called Pretzer that is actually pending before this court on a interlocutory evidentiary issue. But in Pretzer, the state FDLE is the defendant there, and they're arguing that the process is not to file an action in the trial court, and that we don't have any standing or authority for these individuals that they're denying a purchase of a firearm to bring an action against their rules. So it doesn't matter what people in these positions are doing. FDLE argues that they must use the other procedure.
So at any time, did you request a 12057 hearing?
Your Honor, we did not, because we have a companion case with this one, which is the consolidated mandamus case. FDLE never told Mr. Lynch he was entitled to a 12057 hearing. And in fact, they do not give 12057 hearings on these cases. We could not even get them to file a final order and render a final decision. The letters that the record on appeal contain just continue to tell him, your choices, sir, are go to New York or go to Nix, but you can't make us prove or give you any documentation. And again, going back to their own rules, Your Honor, if their rules were applicable to this case, they're supposed to give him the document that they're relying on. And that goes back to the related question of federal and Florida law being consistent, that the inclusion of a name on a list is not a factor that Brady Act considers a prohibiting factor. And I want to make clear for the court, we're not saying that FDLE can't rely on that name on a list at the point of sale to deny the right, to issue an initial denial. What we're saying is, once the person comes forward and says, I'm not sure what you're talking about, you don't have any, we don't know about this, you don't have any evidence, show us the evidence. If FDLE cannot at that point produce the evidence, they have to approve the purchase. And Your Honor, the Sanders case talks about this in detail. They want to distinguish Sanders and Ross because they say Sanders and Ross were arrest cases, not a person who was on the list as being supposedly finally prohibited under a final ruling. But the procedure in Ross actually did address that because Mr. Ross was initially denied based on a murder conviction. The court said that it is the government's job to go to the state that is reporting this record, find the murder conviction, and if you can't find the murder conviction, or if you find that the murder conviction has been overturned or pardoned, yes, state, you have to go ahead, not just and give him the firearm, but you cannot continue to keep that record on your system, and you must clear his name as to that record completely once you don't find the evidence.
Counsel, let me add, go ahead, Judge Rowe.
Okay. Just wanted to follow up on the distinction between the point of sale and then the challenge by the person seeking the permit or the weapon. Why is there a distinction? Why should why can the seller be able to rely on the NICS index entry at the point of sale and FDLE in terms of disqualification, and it's not until the time that it's challenged that FDLE should produce the record that you're suggesting needs to be produced?
Well, Your Honor, and let me be clear, I was speaking to a very specific example that in this case, we are not challenging. That doesn't mean that in some future case, it may not be an appropriate challenge. But the reason I'm making the distinction here is there is obviously a laudable purpose to the Brady Act and to Florida's law. And the way the process is supposed to work, and this is actually the subject of the other case, is at the initial point of sale, if there's information on this list that indicates the person is prohibited, Brady does tell the FDLE to deny at that time, and then the person has rights of review of the record. If it is a potential prohibitor, but not a clear prohibitor, the Brady Act and Florida law gives FDLE 3 days to do their, well, federal law says 3 days, Florida law says 24 working hours. Excuse me, well, it's 24 working hours to go and investigate and see if they can find the record. And that's actually the specific issue in the Sanders case is NICS in that case, because we are an exception. We're one of only a few states that are point of contact states. Most dealers go straight to NICS in other states. But in our state, we go through FDLE to go to NICS. And in Sanders, they saw an arrest record that was a potential prohibitor. And so Nick said, well, okay, we've got 3 days to go and look this information up and see if he is actually a prohibited person and get the document that shows he's prohibited. And they couldn't find it in 3 days. And so when the 3 days was up, Mr. I don't even want to mention the young man's name, was able to go buy his firearm and obtain one at that point. The distinction that we were making here is we're not challenging, that process is not an issue here. FDLE arguably had sufficient evidence at the point of sale to tell the dealer, deny this transaction. At that point, then the purchaser says, okay, fine, you've denied me, give me the evidence, give me the record. In fact, FDLE's records or rules require that for criminal history denials, that they are required to give the person the record or the evidence on which they're basing it.
Counsel, let me jump in here and ask the question that I was going to ask a minute ago. What is in our record? What is in our record on appeal showing what FDLE got from NICS?
Absolutely nothing, Your Honor.
Okay, whose responsibility was it to put that in the record for us?
I believe that is FDLE's responsibility because FDLE is the one who is claiming he is a prohibited person. They are the ones who supposedly do the research under the statute are obligated to do the research. That is their job to go find evidence to support their denial of a fundamental right. I would point the court back to the Talby case. When we have a convicted felon standing before a trial court and the state wants to enhance that previously convicted felon's sentence based on a prior felony conviction, it is the state's burden to bring before the court a certified judgment and sentence showing that this person was convicted of a felony previously.
So, Mr. Friday, what are you asking? What do you, if you get what you want here, what should our opinion say? What should it require?
Your Honor, I believe that the opinion in this case should require a few things. Number one, that at least when it comes to mental health records as opposed to criminal records, because of the lack of statutory authority, under mental health records, FDLE is obligated to use normal 120 processes, not their own rules that they have created. Second, Your Honor, we would argue that FDLE we would think the order would require and state clearly, FDLE has the burden of proof in these cases, and it is their burden to go obtain the record that they are using as a denial. And if they can't obtain
So do we say that Mr. Lynch is allowed to buy his firearm, or do we remand for an evidentiary hearing where evidence has to be produced? What do we say?
Your Honor, I think that in this case, given the passage of time and FDLE's admitted inability to produce any admissible evidence of such a record existing, I think this particular case, the action of the court should be approve Mr. Lynch's purchase and notify NICS that you have not been able to obtain proof of this alleged commitment. In future cases, I think it should be made clear that FDLE has a burden under Chapter 120 to give people a hearing and notify people of their right to request a hearing under the 120 statute.
Okay.
I'm into my rebuttal time.
You're in your rebuttal time. You can keep talking if you want to, or you can save it.
No, Your Honor. Thank you. I'll reserve rest for rebuttal.
All right. Thank you, Mr. Friday. All right, Mr. Faruqui, you're up. Did I say that correctly, sir?
Yes, Your Honor.
Okay. Thank you.
Good morning. May it please the court, counsel. My name is Bilal Faruqui, and I represent the Department of Law Enforcement. This case implicates several compelling interests. First, of course, is the ability of law-abiding individuals to promptly purchase guns in order to exercise their right to bear and keep arms. On the other hand, we have the government's interest in ensuring public safety by implementing and enforcing longstanding prohibitions against gun possession and purchases by felons and the mentally ill. We've also got the privacy interests of mental health records to consider, as well as to a certain extent the constitutional requirement to give full faith and credit to the records of other states, as well as the right to interstate travel.
But we don't have any record from another state, Mr. Faruqui. We have a printout that's alluded to in letters, but we don't even have a printout from NICS. We have no evidence to support what the department did.
So first, I would like to address the record on appeal, and it's my understanding that the arguments presented below by appellant were first that it is FDLE's burden to get a copy of the original New York record, and that the procedure in place was inadequate. There was never an issue below about whether or not there was actually a record in NICS that identified appellant. So for that reason, you know, it's not included in the record. And I would also point out that, you know,
Mr. Faruqui, if you were at a trial and there was a witness, you know, put in the box by the other side, and you wanted to inquire about their criminal history, if they had any felony convictions, it would be, you know, a violation of lawyer ethics, and you could be disbarred if you asked that question when you didn't have a certified copy of the final judgment and sentence in that felony. So in this case, we have, you know, what Heller says is a fundamental right, and the government is saying that you can't exercise your fundamental right, and all I have to say that you can't do it is a printout.
Right. So we didn't have a trial in this proceeding. The question presented in this case was a legal and procedural question.
Okay, so where does a person similarly situated go to have an evidentiary hearing and have an adjudication on this?
All right. So Mr. Lynch's next step, and as far as the administrative process, would have been to go to the state of New York to attempt to correct the record or obtain relief from firearm disability. And if he was unsuccessful, then under Title 18 United States Code 925A, Mr. Lynch has the availability of filing a cause of action in a trial court, in which case there would be an evidentiary hearing on whether or not he was prohibited. And these types of cases have been filed. Appellant has cited to a couple of those cases, and we've cited.
So give me that site again.
It's 18 USC 925A, which explicitly creates a cause of action for individuals who believe they've been improperly denied a purchase of the firearm under the Brady Act.
So where's that filed?
Pardon?
Where would that be filed?
That would be filed in a trial court. And
in a Florida trial court?
He definitely can file it in a district, in the federal district court. I'm unclear whether it could be filed in the Florida court as well.
Okay, I'll look it up. Thank you.
Counsel, is it FDLE's responsibility to tell applicants or their lawyers what procedural options are available to them?
Well, of course, it's their responsibility, and they have. And if you look at the letters included in the record, the letters informed, first of all, the basis for the denial, which was a New York record, provided the contact information for the agency responsible for the record, and provided a record identifier number for the record. And so that was Mr. Lynch's, notice. And then Mr. Lynch was initially informed that he could seek correction through or relief from disability through the state of New York, as well as the federal government through the NICS section. And once it became clear that Mr. Lynch apparently was not choosing to elect that route, the FDLE additionally informed him of the other available remedies, such as filing the cause of action.
So as I understand Rule 11C8001, if you're dealing with a 120 agency, you can petition for a 120 hearing, I guess on the disputed issue of fact as to whether or not he's actually disqualified for mental disability. There's also an alternative special hearing panel if you're not dealing with a 120 agency. Is that correct? Right.
So 11C8001, of course, says that if there's a disputed issue of fact, and 11C8001, let me preface that involves a criminal records history. So it directs the applicant or the challenger to seek his administrative hearing with the agency that originated the record. Mr. Lynch, if that rule were to be followed, Mr. Lynch's remedy would remain at the state of New York. And of course, the state of New York would not be subject to Chapter 120. So if 11C 8001 applied, it would be the special set of procedures that are outlined therein.
And what procedures are available to an applicant who, for instance, claims that the whole rule itself is invalid, or that the statutory setup for challenging a denial is unconstitutional? Where are there points of entry to raise those constitutional or invalid rule issues?
So I think that as far as the constitutionality of the statute, I don't think that that the appellant is challenging that. I think they made that clear in their reply brief. But of course, the constitutionality of any statute can be challenged in a trial court in a declaratory action, and I'm not aware that there was a indication before, in the proceedings before the FDLE that the appellant was challenging the rule, but certainly there are procedures available for rule challenges as well.
Okay, one more question, and I apologize for interrupting your flow, but exactly what did FDLE get from NICS?
Right.
And is it in our record? I mean, what does it look like? It's not in our record, right?
Right. So obviously this is not included in the record, but the FDLE queries a computer database essentially, and what the computer database would inform FDLE about is that there is a record entered by the state of New York, and whatever information the state of New York would have provided into the system. And in terms of mental health records, pursuant to New York law as well as HIPAA regulations, mental health records are to be entered into NICS, but with only the limited information required to establish, the identity of a person, as well as the fact that, or what prohibits them. So NICS, so obviously the FDLE would see an entry in NICS saying this person is disqualified based on this particular statute, and this agency is the agency that entered the record.
Thank you.
Counsel, at a minimum, should FDLE not at least produce a copy of that index entry to a person challenging the denial of the permit? I mean, just to facially determine that, it's John Doe at 2000 Drayton Drive who has been denied this record. So at least facially, the person challenging the denial knows that, FDLE was relying on a record that seems to match that person.
So one of the issues here is that the NICS index, just like other, federal criminal justice databases such as NCIC, III, etc., they're all confidential law enforcement databases with specific rules about use and dissemination of the records. So FDLE believes that it cannot be disclosed in the way that a criminal record could be disclosed under the procedures available in statute.
So you're saying that someone can be denied a fundamental constitutional right and has no standing to see whatever document or what you're relying on. You say you're denied. New York says you're denied. Go talk to New York, and we're not going to tell you what New York told us.
Well, I would clarify that FDLE did tell appellant, this is what New York has stated and has provided the record number. So it's FDLE's position that should be sufficient, for the person to follow the procedure and determine sort of whether this record needs to be corrected. Certainly, if this court finds that FDLE is required to provide the printout from the NICS index, FDLE will obviously have to follow that. But At this point, FDLE.
And I think I've seen those. Not in this case, but in other cases, I've seen a copy of that printout. So I'm not sure if FDLE thinks it's confidential, they don't think it's confidential in all cases.
Right. So again, this is straying far from the record, but the FDLE, the FBI has, and the Department of Justice has promulgated rules about use of its rules as well as policies about use of its information. And the policy of the FBI is these types of databases can be disclosed to courts in criminal justice matters. So, purchase of a firearm it wouldn't necessarily fall under criminal justice. So, in other words, if you've got a criminal case and we need to share a criminal record with the court, that's certainly allowable. However, there's no specific policy that allows dissemination in this particular circumstance.
And that is controlled by federal law, not state law, correct?
That's correct. And as we mentioned in the brief, FDLE is basically acting as an intermediary and implementing the federal regulations, and has an obligation to apply the federal statutes and regulations in addition to the Florida statutes.
And again, if Mr. Lynch or another applicant thinks it's an unconstitutional shifting of the burden to the applicant to disprove the record that has been disclosed or has been referenced, then what is the procedural option? What is the procedural avenue to challenge that?
To challenge the statute, you can file an action in the trial court. If he's challenging Florida statute, he would file an action in the state trial court.
And is it FDLE's obligation to tell these applicants or their lawyers what they have to do to challenge it if that's their argument?
So FDLE obviously, well, they don't have an obligation to inform counsel for an applicant of sort of available constitutional challenges or that sort of thing. Obviously, they have an obligation to provide them notice of the further administrative proceedings available, which is what happened in this case. That notice and opportunity was provided. I see that I'm coming towards the end of my time, so I would just note again that FDLE also questions the appealability of its letter, and we'd rely on our brief for the arguments on that issue. And if there's no further questions by the court, we would ask for this court to either dismiss the appeal or affirm the proceedings below. Thank you.
All right, thank you, Mr. Faruqui. Mr. Friday.
Yes, Your Honor, thank you. Your Honor, first of all, to be clear, what we're talking about is not the underlying mental health records of Mr. Lynch. The Florida statute requires a court action. The federal law requires a court, board, or commission record. So we're not talking about the doctor's records of treating him if such thing occurred. We're talking about just the copy of the record that says this board, this commission, this court orders this person committed for mental health treatment or for substance abuse. There was no argument below. There was no record below in terms of what positions Mr. Lynch did or did not take, other than we sent a letter asking after the court said it's not a final order yet. We sent a letter to FDLE saying, are you going to file the final letter? File a final decision in this case? Their response, no. We went through the mandamus process and suddenly FDLE decides, oh, never mind, we're going to file the record. But Your Honor, I would point you to the actual documents and letters that FDLE put in the record. FDLE does have an affirmative statutory obligation under Chapter 120 to notify persons who are before them when they deny a substantive right or make a decision affecting substantial interest, that these are your remedies under 120. 925A is not an exclusive remedy. There is nothing in the Brady Act that says state remedies aren't available to people as well. And I would point the court, if you review that record of FDLE's own letters, not once do they tell Mr. Lynch anything other than go see the state of New York, or you can go through our criminal history process.
Well, counsel, wasn't that because the scope of this proceeding is very, very limited in front of FDLE? And so I think what they were saying was, to the extent that you have these constitutional or process questions, that's outside the scope of this proceeding. Isn't that a fair characterization of their position?
I think that might be a fair characterization of their position, Your Honor, and we would argue that because they are a state agency, because they are subject to Chapter 120, when they make a decision affecting substantial interests, they have a burden at that point to notify the person under 120 of their rights and to notify the person that they have this right of review in front of FDLE or with DOA. And that's what they did not do. That's one of the things they did not do here. And they shouldn't be allowed to now suddenly claim, after we've been in mandamus and in this case, oh, never mind, we want to go back and give him the hearing, that when we refuse to even render a final decision or give him a hearing on that to reach a final decision in front of themselves.
All right, thank you, Mr. Friday. Thank you,
Your
Mr. Faruqui. We appreciate both of your arguments, and this panel will stand by until our staff puts the next group of lawyers before us. Everyone have a good day.
Thank you.